And you will see there is a lot of, in general, in popular media, especially in media, most of these bans and these legislations, they usually have a media campaign leading up to them. Firecrackers, there was a media campaign leading up to it. Sabarimala judgment, there was a media campaign leading up to it. In the Jallikattu campaign, there was the Jallikattu judgment, there was a media campaign leading up to it, and so on and so forth. What enables this kind of wide-ranging public interest litigation and wide-ranging regulation and interference in specifically Hindu affairs, religious affairs, is the structure of the constitution. And the structure of the constitution, there are certain aspects which give freedoms to practice religion with caveats. The essential practices doctrine, from being any practice which is essentially religious in nature, which was a wide-ranging freedom, from that it has been whittled down to essential practices in the Ajmer Sharif case, and then in the Sabarimala case it has been thrown out of the window. We don't even care whether your denomination or your what your duties are and what it says. If we find that it is in conflict with constitutional morality, we reserve the right to throw it out. We reserve the right to, the judges or the bench of the Supreme Court reserves the right to intervene. The last lecture and the discussion after the lecture kind of dovetails into my topic. In the last discussion, we were discussing about how wealth of temples can be managed, and participation in bonds and financial schemes which will monetize the wealth of the temples, which is largely in the form of gold and ornaments and artifacts and such things. So the big doubt that was raised here was that if the temples do not have an independent management, and if they are unable to make a educated, informed choice, how will the scheme work? So that is a larger question of general rights in terms of freedoms offered for managing religious institutions, and that dovetails into freedom offered for rituals, practices, and general the practice of religion as such. And what we find is that there has been a slew of judicial activity over the last 15 years or so, which where the judiciary has stepped in and very often made wide-ranging judgments of wide-ranging impact on conduct of festivals, on rituals, observances. So you can there is a history to it, right from starting from bans. There was a legislative action in the early part of the 21st century to ban animal sacrifice in temples on the part of the Tamil Nadu government, which had to be taken back after a lot of public outcry and a lot of popular discontent over the proposed act. However, there are other things which have come from the center, from the Supreme Court, which have been challenged on the ground in terms of popular sentiment, but which have still held sway. So we can take examples of the Sabarimala judgment of last year, where the restrictions on who can and cannot offer worship at the temple at what time and so on. These freedoms were of the temple to manage its own affairs with respect to ritual practice were set aside by the Supreme Court. Similarly, the Supreme Court also set aside the practice of bullfighting, Jallikattu, which resulted in a lot of popular outcry and popular discontent. There are even recently the Tripura High Court had banned the practice of offering animal sacrifice at the Tripureshwari Mandir. And there have been other bans. I mean, the courts have interfered on, there is the Dahi Handi, where you have a Dahi Handi in Maharashtra, where people form a human pyramid. There, the courts have intervened and said what should be the height of the Dahi Handi, how many people should participate, and so on and so forth. And basically the courts have taken a wide brief to mandate and regulate religious observances. And it is not, I mean, last year again we saw the ban on Diwali firecrackers on the grounds that they were causing pollution and particulate pollution and so on, which despite a lot of facts and information being provided saying that the main cause of the pollution was not the firecrackers which were fired off during Diwali, but due to crop stubble burning around the national capital due to different changed agricultural practices, but still that was not admitted by the court. You had again bans on cockfights during religious festivals. You had restrictions on Nag Panchami on grounds that Nag Panchami festivities were harmful to the snakes, and where the snakes are worshipped, but people said it was actually you are torturing the snakes. And you will see there is a lot of, in general, in popular media, especially in media, most of these bans and these legislations, they usually have a media campaign leading up to them. Firecrackers, there was a media campaign leading up to it. Sabarimala judgment, there was a media campaign leading up to it. In the Jallikattu campaign, there was the Jallikattu judgment, there was a media campaign leading up to it, and so on and so forth. Now there are various aspects to it. One of them is that there is a lot of this interference is on the part of the judiciary is due to suits or lawsuits and litigation filed, public interest litigation filed in the courts by organizations which have some, may have some vested interest in the way these litigations are run. That's an angle from the foreign funding perspective, which I'll probably touch upon. I have touched upon in another discussion, but which we won't touch upon too much in detail. What enables this kind of wide-ranging public interest litigation and wide-ranging regulation and interference in specifically Hindu affairs, religious affairs, is the structure of the constitution. And the structure of the constitution, there are certain aspects which give freedoms to practice religion with caveats. So I would like to point your attention to certain articles of the constitution. Article 19 says that protection of certain rights regarding freedom of speech, to assemble peacefully, to form associations or unions, to move freely throughout the territory of India, and to practice any occupation, carry on any occupation, practice any profession, etc. So there is a state that it says that nothing shall affect the operation of any existing law or prevent the state from making any law insofar as such law imposes reasonable restrictions on the exercise of the right in the interests of the sovereignty and integrity of India, the security of the state, friendly relations with foreign states, public order, decency or morality, or in relation to contempt of court, defamation or incitement to an offense. Now this is about regarding the freedom of speech, assembly, freedom of association, right? So you have the freedom of association, but it is subject to reasonable restrictions with respect to public order, decency, morality, right? So that is Article 19. Article 25, freedom of conscience and free profession, practice and propagation of religion, and that as soon as you say that the Indian state guarantees freedom of conscience and free profession, practice and propagation religion, it immediately says that it is subject to public order, morality and health. So, and there is a specific Article 25 2b which says that nothing in this article shall affect the operation of any existing law or prevent the state from making any law providing for social welfare and reform, right, or throwing open of Hindu religious institutions of a public character to all classes and sections of Hindus. So it is on the basis of these clauses which says that you have the freedom to practice your religion, but there are certain reasonable safeguards. One of the reasonable safeguards is that it should not infringe upon public order, morality and health. It should not infringe upon people's freedom of conscience and their fundamental rights. And it should provide for social welfare and reform only for Hindu religious institutions. Social welfare and reform is restricted only to Hindu religious institutions, Mainly because at the time that the Constitution Assembly was convened, the idea was there were certain protections that were to be offered to people. Right? There were certain practices such as restricting access of people to the temple, which were of a public character. Again, it specifically states that if the temple is of a public character, right, I can restrict. Suppose I have a small private mandir. Suppose I'm rich enough, I have a big enough house, I have a small private mandir in my house, I can restrict access to who needs to come in, who doesn't need to come in. I can say that if you have, for example, I can say that, mutts, for example, do not restrict entry of people in shorts. I don't want to have you in shorts. There is a dress code to my temple. I don't want you to, come to my temple drunk. It's a restriction that I place on my temple, right? Or if I'm a particularly nasty person, I'll say that people of this caste should not come into my temple, right? There is nothing in the law to prevent me from being nasty in my private property, right? It just makes me a bad person. It doesn't make my action illegal. Then 26, freedom to manage religious affairs, again subject to public order, morality and health. Every religious denomination on any section thereof shall have the right to manage its own affairs. I just ignore the other clauses. It says to manage its own affairs in matters of religion. So there are certain things which basically bring, there are certain questions that you have to now ask. Now that we have this basic information about the constitutional provisions, we have to say what constitutes public order, morality and decency, especially what constitutes morality, and what kind of freedoms are covered under this. What is a denomination and what is a practice? So this brings us to certain doctrines which are embedded in the Constitution, the Essential Practices Doctrine. So I'll just walk you through the Essential Practices Doctrine through certain landmark judgments and how it has evolved constitutionally over the years. And also the definition of denomination or the restriction to denominations, certain specific denominations to manage their own religious affairs. And we'll walk through the basic structure, doctrine, which is embedded in the Constitution. So let me first walk through the Essential Practices Doctrine. So anything, if you say that this is a religious practice and I need the freedom to conduct this religious practice, to participate in or to run this religious practice, it has to pass the Essential Practices Test. What is this Essential Practices Test? This entire test and the doctrine of essential practices was evolved through several landmark judgments. The first one is the 1954 Shirur Mutt case. In the 1954 Shirur Mutt case, most of these judgments, most of these doctrines are expounded in cases and in judgments where the original case was not really directly related to the doctrine, but it was some other kind of dispute. In the Shirur Mutt case, the Shirur Mutt is one of the 8 mutts in Udupi which manage the temple in a rotation basis. It's called the Paryaya system, where the Swami of each mutt, 8 of these mutts, the Swami of each mutt manages the temple and offers the primary worship at the temple in a rotation system. They have a period, the Paryaya period. So one of these mutts is the Shirur Mutt, and the Swami who came into the Mathadipati's the seat was Lakshmindra Tirtha Swamiyar. And this Mathadipati, when he came to his seat, he was a junior. He was a minor, and therefore there were people managing affairs for him, the mutt's affairs for him. And after he came into his majority, he started managing affairs by himself. The mutt ran into financial difficulties and they were forced to go out and borrow money and so on. And therefore, at that point in time, the Shirur Mutt and the Udupi region was under the Madras Presidency. And the Madras Presidency had a Hindu Religious and Charitable Endowments Rule Doctrine, Act. Under the Act, they appointed somebody to come and manage the affairs of the mutt. And afterward, there was another person. This person became the proxy for somebody who wanted to take over the entire mutt's affairs, just keep the Swami as a figurehead and manage the entire affairs. And eventually this transformed into a power struggle where the Swamiyar had to evict the person appointed by the HRCE board. And among the points of contention were the practices which were carried out in the temple by the Shirur Math Swamiyar, and the question came up as to whether this is freedom of religion and whether it is essential practice. So in this judgment, there is a interesting section of this judgment where I'll read it out to you. In the first place, what constitutes the essential part of a religion is primarily to be ascertained with reference to the doctrines of that religion itself. If the tenets of any religious sect of the Hindus prescribe that offerings of food should be given to the idol at particular hours of the day, that periodical ceremonies should be performed in a certain way at certain periods of the year, or that there should be daily recital of sacred texts or oblations to the sacred fire, all of these would be regarded as parts of religion, and the mere fact that they involved expenditure of money or employment of priests and servants or the use of marketable commodities would not make them secular activities partaking of a commercial or economic character. All of them are religious practices and should be regarded as matters of religion within the meaning of Article 26B and Article 25(2)(a). So, what it says is, if you go through the essential practices test, 1954 Shirur Math judgment, what it said was, an essential practice should be essentially religious in practice. It should be essentially religious in nature. If it is essentially religious in nature, the state does not have any authority to comment on it or to regulate it. Except where there is, you can have a religious ritual where people there are religious rituals where there are aspects of self-harm. For example, there is the Madasnana, where people eat and then the people roll over those leaves after they have eaten. There are hook swinging practices where people get themselves strung up and hung by a hook, which is plunged into their flesh. There is an aspect of self-harm, but you cannot as long as it does not exceed certain limits and actually involve human sacrifice, or there were certain practices like children being buried alive, which I read in the newspapers, which I cannot trust, but the children were supposed to have been buried alive for some time and then brought out or something like that, which was pretty disturbing the way it was described. So maybe things like that the state would have a Muharram is essential practice, which the state does not interfere in. But even if there is self-harm, swinging from hooks is similar to Muharram, where people actually cut themselves open with sharp objects. So the state will not interfere, except if you are giving human sacrifice or you are going to commit suicide or something like that, right, which is extreme in nature, in which case the state will deem it necessary to intervene. So that was the Shirur Math case. So basically in 1954, and the Shirur Math case, there weren't too many precedents from Indian jurisprudence. So a lot of the precedents which they drew were from Commonwealth countries which followed the British system of jurisprudence. They took examples from, I believe, New Zealand and from England, cases in England, and essentially arrived and then came to this definition of an essential practice, which is that it should be essentially religious and therefore it is covered under freedom of religion. The next case was in 1958, Venkatramana Devaru versus State of Mysore. In 1950s, once the state of Mysore adopted the same temple entry rules which had been adopted by the Travancore state before independence, and the Travancore state's temple entry law had been brought in, with the slight changes, had been brought into force in Madras Presidency also, and the state of Mysore adopted that. Now there is a temple in Mulkipeta in the west coast of Karnataka, and this temple was run by God Saraswat Brahmins, community of God Saraswat Brahmins on the west coast of Karnataka, and they said that the laws of temple entry should not apply to them, since they were a denomination, and as a denomination they had the right to reserve entry, and since the temple had been set up as part of when their community actually came and settled in that place, the temple was established for the benefit of their community. Therefore, A, they were a denomination, B, it was not a temple of a public character. And therefore, the rules of temple entry should not apply to them. They wanted exemption from the rules of temple entry. And the case was decided against the community, the Gaud Saraswat Brahmin community. And the reason was that they were not determined, they were determined to be a denomination. They were given the status of a separate denomination. But even though the practice of exclusion was essentially religious in nature, there was an exclusion, and throwing open temples for worship by all parts of the Hindu community had become an imperative for the constitution, for the government of India within the Indian constitution. Therefore, they could not restrict entry, general entry to the temple, but as a denomination, they had certain rights to partake in certain rituals of the temple, where they and they alone had their rights, and therefore this was seen as an essential practice, and they had their rights. And so this added a small tweak to the essential practice doctrine. It said that this was essential and you had your rights, and there were general rights. There were specific rights to the community and there are general rights. We will not infringe upon the specific rights of the community or the denomination, but we will not extend it to all general rights, saying that you had complete and free access to managing all affairs of the temple, including getting to decide who enters and who doesn't enter, because the temple, while it had been established for the Gaud Saraswat Brahmin community, it was also for the benefit of the entire community and all the people of all communities around in that region, and therefore it was of a public character. So there was a tweak to the essential practices doctrine from this case. The next case restricted the essential practice, the definition itself of a restriction, essential practice. And this case was a case in 1961. The Dargah Committee of Ajmer versus Syed Hussain Ali and others. So there is a background to it. The Ajmer Sharif Dargah is the Dargah of the Sufi saint Khwaja Moinuddin Chishti. And there was a community of Khadims who were associated with the Dargah. They were supposed to be descendants of companions of the Sufi Khwaja, and they were all members of the Sufi Chishtiya order. And during over time, there was always some form of state interference. During Akbar's time, before Akbar's time, the Dargah was not in a very rich state. It was it was a kacha structure with people occasionally traveling there and going there. And after Akbar's time, a committee was established, and the state actually intervened and helped people make it a pakka structure and set up a committee to manage its affairs. Now the Dargah committee and the Khadims, the hereditary Khadims, came into a conflict. The primary reason for the conflict was that people used to go to this mazar at Ajmer Sharif, and they used to make offerings. A good portion of the offerings, it was taken by the Khadims. And there was a agreement reached with representatives, the administrative representatives, whereas these Khadims who had a ritual role to play, and the administrative people and the Dargah committee would get a share of the money which was given to the temple. Now in 1961, so before that, before independence, there was a case saying that the Khadims had a right to the offerings and the nazars made by the pilgrims at the tomb and at the Dargah, and it had gone back and forth, and it had gone all the way till the Privy Council in London. And they said that there was a fundamental right to property. As a denomination, they had a fundamental right to property, and this was the property of the Chishtiya order of Sufis. And then when again they came into a conflict with the Dargah committee, the submission made before the court was that the Ajmer Dargah was the property of the Chishtiya Sufi order, and the Dargah committee was of general Hanafi Muslims, Muslims who followed the Hanafi order, for Hanafi school of jurisprudence, and therefore this was an infringement of their rights as a denomination. The case was disposed against the khadims. And there was an important observation, so to speak, made by the Honorable Court in this case. It says his religion is a matter of faith with individuals or communities, and it is not necessarily theistic. It has its base in a system of Plia's doctrines, and but it is not correct to say that. So after that, it say that religion itself is nothing but a doctrine or belief. A religion may not only lay down a code of ethical rules for its followers to accept, it may prescribe rituals and observances, ceremonies and modes of worship which are regarded as integral parts of religion, and these forms and observances may extend even to matters of food and dress. So it says that similarly, even practices, though religious, may have sprung from merely superstitious beliefs, and may in that sense be extraneous and unessential accretions to religion itself. Unless such practices are found to constitute an essential and integral part of a religion, their claim for the protection under Article 26 may have to be carefully scrutinized. In other words, the protection must be confined to such religious practices as are an essential and an integral part of it and no other. This is a very, very critical point, and this marks a very important turning point in the essential practice doctrine. Earlier, a practice was held to be essential practice if it was essentially religious in nature. Now, the practice is held to be an essential practice only if it is an essential part of the religion. Right? Somebody, I think it was Hari Prasad, one of the people who works in this area, who made the observation that freedom of expression is an absolute and unfettered right. And it is an absolute and unfettered right only with restrictions with respect to harm. You cannot harm people. For example, you cannot shout fire in a crowded theater where there is no fire. Right? If there is no fire and you shout fire in a crowded theater, that is harm. If there is a fire in the crowded theater and you shout fire and there is a stampede, you are acting in good faith. You are trying to save people. So that is the nature of freedom of expression. Other than that, I can say whatever comes to my mind. Right? I cannot state that your rights are limited, rights of expression are limited only to essential expression. For example, this entire talk that I am giving is not an essential expression. An essential expression would be for me to come and say that I want tea, or I need to buy a ticket. Anything beyond that is it's not really an essential part of expression. So you cannot say that I do not have any freedom to come and make this talk here because it's not an essential exercise of the freedom of expression. Same way, freedom of religion, you cannot say that your freedom extends only to what is only essential. My freedom might extend beyond, of religious practice, may extend beyond what is essential. And if you apply this essential practices doctrine in Hindu religion, almost everything will be found to be unessential. Right? There is nothing which mandates that I have to go to a temple every morning. There is nothing which mandates that I have to ring a bell. Right? There is a puja paddhati which says that I have to ring a bell. Right? And it is not for every denomination. For example, some puja paddhatis might say that you don't need to ring a bell. You just mentally, recite some prayer and you're okay. You don't need to ring bells or show a camphor or, light an agarbatti or whatever. But if you restrict it, then what is essential? There is nothing which is essential. Then again, if you say that it is for freedom of denominations, then what is a denomination in Hinduism? A Swaminarayan Mandir belongs to the Swaminarayan denomination, which is very specific. But who does the Tirupati Mandir belong to? There is no denominational restriction on the Tirupati Mandir. Right? But there are restrictions saying that only a priest from the Vaikhanasa school of Agama school, Vaikhanasa Agama school, can be a priest at Tirupati. Right? Is Vaikhanasa a denomination? No, it is only a school of Agama. You cannot call it a denomination. So under this practice, you cannot call almost no Hindu except for maybe the Arya Samaj or maybe the Isha Yoga Foundation, or maybe the Arya Samaj can be called a denomination. Swaminarayan can be called a denomination, but the vast majority of Hindu practice does not fall under any specific denomination. Therefore, no freedoms can be guaranteed. And if you guarantee only essential practice, then there is no essential practice, right? So essentially, if you look at it, then a lot of questions crop up. Now, after this, the other landmark judgment where there were certain very far-reaching observations made was in the Sabarimala case. Indian Young Lawyers Association and others versus the state of Kerala and others. Now, the Indian Young Lawyers Association, that's a very interesting case. I'll tell you about the genesis of the case itself. There was a major controversy that there was I'll give you a bit of a background. In Sabarimala, there is a practice of a Deva Prashnam, where all matters, I mean, whether you have to build a roof here or whether you should build these stairs this way, everything is decided by directly consulting the deity. And the deity is consulted by means of a Deva Prashnam. Deva Prashnam, where there is a process and the answer is that deity gives you an answer. So during a Deva Prashnam, there was a controversy which erupted saying that the deity had, there was the deity's brahmacharya or his brahmacharya state was being disturbed due to women, presence of women or something like that. And because of that, the Tandri, one of the presiding Tandri or the chief priest, came under fire because there were wild allegations of corruption on the part of the Tantri and so on. And at that time, a Kannada actress came up and made a statement saying that it could be because of me. And the reason she gave was she was there in the temple, she was there, had gone for darshan, and there was a crowd and she was pushed and she went and fell on the idol. So having been to Sabarimala, it seems very far-fetched to me, because there is a distance of about, at least 5-6 meters, and it's on a raised platform with 4 steps, 3-4 steps. And then there is the idol is inside, beyond 4-5 meters beyond a raised platform. However much there is a crowd, if you fall, you will fall on the stairs. You can never get inside. You can never be thrown inside and actually go and touch the deity. But anyway, after this there was some kind of Shuddhikaranam or something like that done, because a woman had visited, and this appeared in NDTV, I believe, as a news item. And the people in the Young Lawyers Association, they saw this and saw that this was a infringement of fundamental rights of women. These are people who have nothing to do with the temple, who are, even if it is thrown open to everybody in the world, they are not going to visit the temple because they are not interested in the temple, and these people filed suit. So it was taken up. Then there was another lady who asked to be included in the this thing. The primary respondent was the Indian Young Lawyers Association, who eventually withdrew, but then there was a secondary impleader, which was the person was leader of the Indian Young Lawyer Association, but the secondary the person who impleaded was a college student from Punjab University, second year college student, BA student from Punjab University, who impleaded herself. Nobody knows what she looks like, whether she really exists. This is between the years 2006 to 2018 was when this all happened. And this Punjab University student was sometime in 2012 or 2013. The person is Nikita. The name, we are not sure whether it is Nikita Anand. In some places it appears as Nikita Anand. In some places it appears as Nikita Azad. We are not sure who this person is. I don't know what she looks like, and she ran a campaign, I believe, called Happy to Bleed or something like that. And a Supreme Court lawyer represented her. She impleaded herself in the case, and eventually the Indian Young Lawyers, towards the end of the trial, this Indian Young Lawyers Association actually withdrew from the case, and the case was run on behalf of this person who had impleaded, whom we don't know whether she really exists or not. But anyway, the court did take it up, and the critical things, as part of the judgment, there were certain observations that the bench made. The court should adopt a differential attitude to such cases touching on religious matters and deem the practices under scanner as essential, but nevertheless investigate whether such customs, beliefs or usages violate fundamental rights of an individual. This is a very interesting observation. They say that we may not have the competence to determine whether a practice is essential to the religion or not. We may not have that competence. We should adopt a deferential attitude to whatever the respective experts are saying. But we always have the freedom to examine whether it violates fundamental rights of an individual. In which case they held that this violated the fundamental right to dignity of the individual. And the morality as defined, because we are bound by morality, subject to morality, the morality is constitutional morality, not public morality. Constitutional morality, and this morality of the constitution is not what is determined by society and by public at that point in time. It is something held to be pristine and inviolate in the constitution, and this must adapt and overcome challenges thrown to it by society. This is outside the judgment. It is an observation made outside the judgment. So which means that it must adapt and overcome challenges even if you don't like it. What's there in the constitution will hold. Even if every single Indian is not happy about it, the citizen is not happy about it, what is the constitution, what is morality as defined in the constitution and as interpreted by the bench will hold. It is not a matter of public opinion. And it should adapt and transform challenges. It is a transformative document. Whole point is, it says that this is a transformative document. The document is not for reflecting what the point of view of society is. It is for transforming society into a certain vision or into a certain mold which the constitution holds. The basic question is whether the recognition of rights inhering in religious denominations can impact upon the fundamental values of dignity, liberty and equality which animate the soul of the constitution. The right of the denomination must be balanced with the individual rights of each of its members. It would be impossible to conceive of the preservation of liberal constitutional values while at the same time allowing group rights to defy those values by practicing exclusions and through customs which are derogatory to dignity. So it says that individual rights as held in the constitution hold, group rights are subservient to this. Individual rights, essential practice is not sufficient to determine that you have the freedom to practice it. It's not necessary. It doesn't even have to be essential. Even if it is essential practice, if it violates certain structure of the basic structure, the basic features of the constitution, we can strike it down and we can intervene. Essential practice. Now this brings out from the essential practices doctrine, we now go into the second doctrine which we want to examine, which is the basic structure doctrine. So for this we need to go back to 1973 to the Keshavananda Bharati case. In 1973 the properties of the Edanir Mutt were taken over by the I believe the government of Kerala, one of the Devaswam boards of the government of Kerala, towards one of their land redistribution programs. And the Mathadipati of the Edanir Mutt at that time was a Shankaracharya, the Keshavananda Bharati Swamigal, and he filed suit saying that his right as a head of an institution and the rights of the denomination were being infringed upon because the denomination had the right to acquire properties and administer properties freely. And in this, this case drew on, and the landmark judgment, there was it raised certain very fundamental questions. And the landmark, it was probably the biggest bench of the Supreme Court which ever was convened was for the Keshavananda Bharati case, in which there were 11 judges. The bench was composed of 11 judges, and eventually they held that there are certain parts of the constitution that is essential or the fundamental nature of the constitution, which they call the basic structure of the constitution. The government, even though there is Article 368 gives the government of the day the right to modify or to alter the constitution, alter and amend the constitution. the fundamental character cannot be changed. So that is the basic structure doctrine. So if you juxtapose both of these, what eventually you come up with is that the essential practices doctrine, from being any practice which is essentially religious in nature, which was a wide-ranging freedom, from that it has been whittled down to essential practices in the Ajmer Sharif case, and then in the Sabarimala case it has been thrown out of the window. We don't even care whether your denomination or your what your duties are and what it says. If we find that it is in conflict with constitutional morality, we reserve the right to throw it out. We reserve the right to, the judges or the bench of the Supreme Court reserves the right to intervene. And even if the government of the day legislates to protect these freedoms, these legislations can be thrown out, because if this legislation is found to violate the basic structure of the constitution. So this is the background, and so this is where we are in terms of what freedoms we have. So essentially the freedoms which are given to religious denominations, to Hindus, are basically, there are pretty limited freedoms. It's at the discretion of the court and at the discretion of the government of the day. So tomorrow if I have a government which is particularly ill disposed towards Hindus, and the government of the day decides that lighting agarbattis is a polluting activity because it produces smoke, they can ban agarbattis in your house. Even if you can produce some texts which say that it is essential that I should do my puja every day by lighting an agarbatti, the courts and the government of the day and the pollution control board can intervene and stop you from lighting an agarbatti. If you ring your ghanti every day at home, it is sound pollution. Your neighbor is disturbed, therefore we can ban you from ghanti bajaving in your. It sounds funny, but I have seen articles where they write about the kind of pollution that agarbattis cause. In one of the usual suspects, the newspapers, there was an op-ed which said that lighting agarbattis is a polluting activity. They said that there was another article which said that all these flowers that are offered in temples, it's it's highly detrimental to the environment because it produces a lot of waste which should be managed properly, and the temples don't manage it. They just throw it and it causes pollution, it causes A, B, C, D. So you can be stopped by this principle. If you take this, if you take it in totality, you can be stopped from offering flowers at a temple, you can be stopped from lighting an agarbatti, you can be stopped from bajaving ghanti, you can be stopped from basically anything.
Sir, Nitish Kumar told Havan is also the polluting activity.
Havan is polluting activity. Everything is polluting activity. See, I will say, if you are Hindu, you are essentially, you are either, casteist, or you are,
Brahminical patriarch.
Yeah, you are patriarchal, casteist, or polluting. Any Hindu, if you are any Hindu practice, will be, casteist, patriarchal, or polluting. It will come under one of those categories. I mean, while it sounds very funny, but this is actually gives far-ranging rights to the state to intervene and interfere in any aspect of activity. Now, how is it that before the Sabarimala case, when the essential practices doctrine was essentially thrown out of the window, before that, right, non-Hindu communities, whether if you take any Christian community or any Muslim community, they belong to a certain denomination. They have certain rules. There are certain essential practices. You have to go to church, you have to go to the mosque every Friday, you have to say prayers in this particular way, and there is nobody can prevent you from doing that, because you are a denomination with a laid down set of rules, with a leader who can decide on what the rules are for you. You have a religious leader. If it's a Sikh, you have a religious leader in your Gurdwara. He will tell you what you need to do. There is a book, there is a certain practice, there are things that you're supposed to do, there are things which you're not supposed to do, and all of that is essential practice, and you have the freedom as a denomination to practice. This is available to all denominations, and it restricts freedom of religion only to minorities, and the state can arbitrarily intervene in the practices of Hindus and Hindus alone. So that is the constitutional structure. Now, this is the part where I could get jailed, but I'm going to go ahead and say that anyway. So I did a kind of comparative analysis between Sharia law and the Indian Constitution. So I just did a basic study of fiqh, which is Islamic jurisprudence. So there are 4 authorities by which you can determine, and every aspect of your life can be determined. What time you should pray, what dresses you should wear, how your property should be inherited, how you should deal with civil disputes, how criminal justice is to be dispensed. All of this, there are very specific, very clear rules. Who can give evidence, what can be admitted as evidence, and what is the basis for determining. Fiqh, it says fiqh is the human understanding of the Sharia. So the Sharia itself is laid down by the Quran and the Sunnah, and the full understanding was there only with God, Allah and His prophets, final of whom will be the Prophet Muhammad. So fiqh is humans interpreting the will of God and the messages which were revealed to the prophets. And the sources of authority, the primary source of authority is the Quran. Second source of authority, next in importance, is the hadith, which are events in the life of the Prophet and his companions. Then that comes to ijma, which is a process called ijtihad, where you collectively reason and there is consensus among scholars of Islamic jurisprudence of a particular generation and the interpretation by Islamic scholars. So if you see why they spend so much time in the madrasas learning the Quran, memorizing the Quran and memorizing the hadith, it's because it's essential. If you have to conduct your life, if the society in Islam, if an Islamic society has to be conducted, you need a large body of people who are well versed in this knowledge to be able to specify what to do and what not to do, how to run things. And ijma is the collective reasoning. Then, if collective reasoning is not available, there is analogy called qiyas, which is at this point in time, there is no collective reasoning. So I take anything which is limited in ijma and then go back to the Quran and the hadith and then do an interpretation of what is there in the Quran and the hadith to make a determination as to if it's a property dispute or a matter of worship, whatever it is, I can make a decision. A scholar can make a decision. Now, the Quran and Hadith is basically, the Quran is the original, the preamble of the Constitution and the Constitution itself. And that would probably be the various judgments which are offered would form the Hadith and the Ijma. And if I'm sitting as a judge on a bench, the bench is the current qiyas. There is the Quran and the Hadith, there can be absolutely no question of any change there. Because it's a revealed word of Allah, the God Himself. There is no way you can go and correct or improve upon the word of God Himself. So there has been some constitutional morality which was given to us in this constitution, and that cannot be changed for all eternity. It is fixed for all eternity. And you can maybe take interpretations. So you would need a large body of lawyers and judges who are well versed, who have studied and memorized this constitution to interpret it for you, to interpret the will of the constitution and constitutional morality for you. So there is a fatwa. A fatwa is a non-binding opinion which you can take from an Islamic scholar. As a lay person, you can go and take a fatwa from a scholar. A fatwa can be for anything. It can be for matters of foreign policy, it can be for matters of how you want to educate your children. It can be even, fatwa says that, how many times should I wash my hands before I start my prayer? You can ask a fatwa on that. It's a non-binding opinion. Same way our courts set up amicus curiae who give non-binding opinions, who will investigate a matter and based on the principle of the constitution, they will give you a non-binding opinion. And similar to the Sharia, we also have jizya imposed upon infidels in India. We also have specific restrictions on what infidels can do and cannot do, which is the freedom of religion which comes with caveats, which is basically impringes among the morality of the constitution. So, it works the same way in a Sharia in a Sharia this thing, in a Sharia country, in a country governed by Sharia, if the infidel has the right to practice his religion. But if the infidel comes out on the street and does his arti or does his ghanti, it violates the sense of propriety of the ummah, of the mu'min, and therefore the infidel does not have a right to violate the sense of propriety of the mu'min. Same way the kufr or the infidel in India, the infidel has his right to go to his temple and do whatever he does, as long as it does not infringe upon the morality of their lordships on the bench. As long as it does not infringe upon their sensibilities of the lordships of the bench, you can bajao a ghanti, and if his lordship or her ladyship decides that your ghanti is immoral, they can put a restriction on it. Well, thankfully we don't stone people to death. But our neighbor has got there. We have blasphemy laws. Article 295 says that you cannot hurt sentiments, and it's in effect a blasphemy law, which says that if you blaspheme against the Prophet or you blaspheme against a particular Christian religion, you blaspheme against Jesus or Mary, you are liable to be punished. And that cannot apply. Blasphemy cannot apply to Hindus because there is no blasphemy, right? I can say whatever I want. I can get up here and say whatever I want, and somebody will find some quote in some scripture somewhere where a great Bhakt says the same thing of his God. So there is no blasphemy here. Therefore, anybody can get on stage and say anything about a Hindu religious figure or a religious text or any religious practice, but the same thing cannot be done for an Abrahamic religion, for people of the book. Our neighbor has gone ahead, and our neighbor, Article 295, somebody was pointing it out. Article 295A only defines blasphemy and defines a punishment for blasphemy. Article 295C is there in our neighbor, Pakistan, where you can be put to death for insulting the Prophet. Death is the... so we are not there yet, but we are getting there. And unofficially, we still, there are people who dole out the death penalty. Since we are not there yet, there are people who are ahead of the curve and who are doling out the death penalty when the Prophet is insulted. So that is the state of affairs. And if you look at why, people are thinking about why. Why is it that you're ringing a bell, or you're lighting an agarbatti, or you're doing something or restricting someone from your temple is such a big problem for him or her, right? I don't have a problem with what you do, what some other denomination or what other sect does, or how they lead their life. Why does somebody else has a problem with me? That's the question that we all ask. And this has been, something which is, which has been, pagans have always confronted with, and pagans simply can't get their heads around this, right? Wherever an Abrahamic religion has set foot as a conquering religion has been, and they start imposing restrictions, the pagans initially say that these people, they do something different, right? They pray 5 times a day, we pray 2 times a day, okay, you pray, no big deal. Okay, you don't eat this particular kind of meat, I don't eat this particular kind of meat, which is okay. We just do different things differently, but probably we do the same things, right? So the pagan thinks that this is just another form of whatever he is doing, he or she is doing. But to the Abrahamic, it's not the same thing. To the Abrahamic, everybody has to have a certain way of working. There's a certain way of worship, and whatever else, there's a certain revelation. Whatever is not part of this revelation is false. And it is a duty. There is, depending upon the denomination, certain denominations, for example, the older denominations of the Orthodox Church or the Jews say that, okay, it's not false, but doesn't belong to me. Somebody is doing it. I don't have any particular need to go and correct him, right? But the later and later versions, iterations of the Abrahamic religious meme, they see a compulsion to go and correct, right? If you take the Protestant religions, they are compelled to come and correct you. It's part of, spreading the good word, spreading the good news is part of their responsibility, right? Same way with with Islam, dawa is a responsibility. Spreading the good word. There is something so wonderful here which you are missing out on, and spreading the word is a responsibility. And therefore, anything that you do is seen as strange if it is not mandated as per a book and as per revelation given by the God who is the single source of truth. And therefore, you have to be corrected. That is the thinking which animates. So that is the same kind of thinking which animates the present arbiters of our fate on the bench. And they say that this is exactly the same constitutional morality which they are talking about. They say that the popular sentiment may not reflect what this morality is, but it has to adapt to the challenges thrown by society, and it has to transform society. The principle of this constitution is to change this society. It is not to help the society run itself according to what it sees as right, but it is to change this society in a certain direction and in a certain image. We want to remake this country in a certain image. So those were some of the observations I had, and this is not without precedent. The Edict of Thessalonica, one of the Roman emperors, basically banned all pagan practices. Offering worship at shrines, animal sacrifice. People say that the Olympics were stopped at certain point in time, some 400 AD or something like that. Nobody says why they were stopped. The Olympics, as with other pagan practices, Olympics, the games at Olympics, and all of these were related to some form of worship of gods, right? So there would be something to do with Zeus or Jupiter or Hera. There would be some form of worship with any kind of activity, with horse races, games, and so on. And so this was a means for the flock, for the pagans to stay away from the church. So therefore the emperor banned it because he said this is repugnant to us. Right? So let me take that. Let us come back 1600 years to 2006 in the Madurai bench of the Madras High Court. In the Madurai bench of the Madras High Court, a case came up. I think it was Muniyasamy Thevar was the respondent. There was a dispute in a temple. The temple used to have an annual fair, some kind of mela. And part of the mela was they used to have a rekla race. A rekla race is where a single ox is tied up to a cart and they have a race. And it was linked to the temple festival, and they believed that it was a belief that if you have the rekla race this year, you will have good rains because it satisfies the the god in the temple, Ainar god in the temple. And there had been a dispute between different castes and different factions in that village, and therefore the religious festivity was stopped. And Muniyasamy Thevar approached the Madurai bench of Madras High Court with a submission asking that the rekla race be continued. Justice Bhanumati was on the Madurai bench of the Madras High Court at that time. She is now on the Supreme Court. And she said that this cannot be allowed. The rekla race cannot be allowed since it constitutes cruelty to the ox. And unilaterally, she included cockfighting and jallikattu practices. She was it was never under discussion, but she included these practices and said these are also repugnant since they involve cruelty to animals. And she said we cannot allow permission. And then you had the activist ecosystem which picked up on that judgment and tried to pass it and took it all the way up to Supreme Court, and a lot of chaos happened. If you look at it, before this judgment or before this, nobody knew what it looked like. Nobody had even seen it. The biggest festival was something which was attended by a few thousand people in a village called Alanganallur, somewhere on the border between Kerala and Tamil Nadu, which nobody even cared about. It would happen for one day in a year, and a few bulls would just run, and some guys would go and hang on to the bull for 30 seconds, and then you can't hang on to a rushing bull for more than 30 seconds. Such a powerful creature. And just fall off. Right? It happens for one day in a year, somewhere in some remote corner, somewhere in this country. And why does the Supreme Court get so animated over it? It's because it's a observance, it's pagan, and it's essentially repugnant. Right? All of this story about, animal rights and women's rights and environment and all that is just the language which is employed. At core, it is this repugnance towards a exhibition of the pagan or the heathen exhibiting their religious practice or their behavior, which is repugnant to an Abrahamic morality at core. That is my submission, and we can question it, we can debate it, but that's my submission, and that's basically the crux of this talk I had to deliver.
Thank you, sir. First of all, I do agree on each and every point that you have mentioned. I also believe that Indian Constitution has been built on values that are alien to India, because, for example, we have blasphemy law. The majority religion has no concept of blasphemy. We have some laws defining the essential practice, and Abrahamic religions may have some pillars, but there is no pillar, or we can say millions of pillars in the majority religion. So we cannot definitely define what's an essential practice or not. But in certain cases, for example, in Ram Janmabhoomi case, there was an incident when the court has to decide if mosque is an essential part of Islam or not. And that was actually used by the Muslim group that this is an essential part, and they lost on it. So this is how the case turned towards and in benefit of the Hindu community. So at some point of time, do you think there has to be some mediation or some control of court defining what thing is essential or not?
See, in my perspective, unless a practice is, unless you're doing something like, passing disease germs or something like that, unless you're doing something which is totally repugnant, like, disturbing people, getting drunk, disturbing people, or public order is being lost, or you're doing some serious harm, like, killing people or sacrifice or something like that, I think you should pretty much, the state should stay out of it.
No, I mean, if that would have been, if it was proved in the court that a mosque is an essential part of Islam, then the current state of affairs in the Ram Janmabhoomi case would have been different. So if something could have been decided by the community itself, because Muslims would have never said that this is not an essential part of Islam and therefore we cannot give up on our claims, then the court has to come into and then decide if this is a part of or not.
See, Ram Janmabhoomi, in my opinion, is less about practice and more about who owns the title to that property, who has rights to that property, who was there first, and who was wronged. Who was the wronged party, who's the aggrieved party, and who is the aggressing party. So that was the crux of the argument, and whether it was essential for the practice of Islam or not was incidental.
Yeah, this was a case that ran parallel with the actual case of Ram Janmabhoomi, but it has very huge importance in deciding the final verdict, which is yet to come. So,
but remember that in the Sabarimala judgment, the essential practice doctrine itself has been thrown out of the window. So then all bets are off.
This is actually with regard to our constitution and the courts. Personally, I am a believer in parliamentary democracy. I do think sometimes, and I'm sure many others think like me, that the court is sort of overstepping its boundaries and getting into areas that it shouldn't be. Case in point being the Sabarimala judgment also, if you may recall, that there was one lady judge who actually ruled in favor of the freedom of religion, which was very ironical. The male judges did not. They had the most, Justice Indumala, that's right. She was the person who actually said the court should not be actually getting into these nitty-gritties of religion, these small matters, but leave religious practices. But we have a parliament, which is actually above the court, if I'm not wrong, that even if they decide that something is not essential, cannot the parliament put in an act and bring it in by majority?
So there is
that reflecting the people, because, and this is the next question, that do you personally also believe, having gone through the constitution, many important sections, that the constitution itself is anti-majoritarian, like what Francois Gautier had said, that it is the only constitution in the world which is against the majority of the country, it's anti-Hindu?
I wouldn't call it an anti-Hindu constitution by design. So first, the liberty of the legislature to legislate acts and laws with respect to freedom of religion will still be constrained by the basic structure doctrine. It says that the Article 368, which gives the the legislature the right to bring acts, the legislature and the executive to right to bring acts or GOs. If it violates the basic structure of the constitution, it can be struck down by the courts. A. So therefore, there is a restricted right to the legislature. Then B, I don't think our constitution was against Hindus by design. There were certain aspects of secular practice in secular states which our constitutional experts took up. See, one thing we must remember at that time was that there was no sense of beleaguered, that Hindus were being beleaguered, or there was no sense of sense of threat to Hindus was far lesser, because there was a partition had happened, and we had said that because of the two nation theory, this question has been settled once and for all, and we've got one country for the Muslims, one country for the Hindus, and so this has been settled. So therefore, this is going to remain secure. Hindus are going to remain secure in this country. Their more concern was about how to protect the minorities, because especially in the wake of violence of partition, how to protect the minorities in this country, and they gave them certain defenses. See, the law is used as both as a sword and a shield. The intent behind the original framers of the constitution was to give a shield to minorities, which were way lesser at that point in time. Christians were a very small portion of our population at that point in time, and the Muslim population was not as big as it is now, because their proportions were not as big, because there was a huge partition, because of which bulk of Muslim majority provinces had gone off into Pakistan. So their concern was about protecting the ability of Muslims and Christians to run their affairs, and the categorization of Sikhs and Jains as minorities was still pretty far from their minds, because the distinction between the Sikh, Jain communities and the Hindu community was not as sharp as it is today, as it has been made out to be today. It was pretty nebulous. The real minorities, I mean, if you take it today, the real minorities are the Parsis in India, who are a real religious minority, and who don't really need any protections, because they are pretty well off in terms of representation in business, in economy, in law, etc. So their concern was with the Muslim leadership, and a lot of the aristocracy had gone off to Pakistan, and the people who remained here were the relatively lesser privileged people. And for Christians, it was a small population. It was about 2 to 3% of the population at the time of independence. So their concern was to give these people a shield. They had never thought that this constitution will be used as a sword against the majority. And that is something which has happened. So if you look at the education laws of freedom to education from 1947 to 1950, when the constitution was adopted, to the adoption of RTE, I think Hari Prasad has got an excellent presentation which says how rights of Hindus were restricted further and further and further. While there was no similar restriction placed on the Muslims and Christians to conduct in educational institutions. So that is my submission. My submission is that it's not anti-Hindu by intent or by design, but it has become discriminatory to Hindus by practice over the years, and through subsequent amendments and judgments and so on.
And there is one reason we can say that it is anti-Hindu, even if not by intent, is that our lawmakers were mostly educated in the so-called secular countries, and had this, the law system, a lot of laws were taken from these countries, where it was a notion that majority is always against the minorities, and they always tend to run over the minorities. And it could have this could have also been a reality in Western countries, but they applied this point of view over on India itself. The majority in India was never like that. It was conspiring all the time to convert every minority religion into the majority. So this could have been a reason that although it was not intended to be made anti-Hindu, But since the laws were taken from countries where the point of view was that majority is always against minority, it was the reason for that.
Maybe. There was also, I must remind you that the Hindu Samaj has been very much on the defensive on certain aspects. Right? For example, a very easy thing to, put you on the back foot whenever you're discussing about freedom of temples, temple freedom, they'll say you are going to hand over the temple to the Brahmins. Right? It's very easy to put you on the defensive because we have certain our own, there are certain weaknesses, right, which we have to acknowledge, right, in terms of, caste discrimination, in terms of, discrimination against women, which we have to acknowledge. For example, the Sharda Act, which was brought in for restricting the age of minors. Before the Sharda Act, we know so many people who got married at a very young age, and early childhood, early pregnancy and death during childbirth, or for that matter, treatment, how widows were treated. I personally, my own childhood, I know ladies who became widows before they even went to join their husbands. They had a child marriage at 9 years and they became a widow. The lady became a widow at 11. She lived till she was 81. She had her head shaved, wore white clothes through her life. So if you just bring all this up, it's very easy to put us on the defensive, right? So I think the framers of our constitution were also of that same mindset where, we at this point in time, with the hindsight of having so much reform and so much improvements in our, even all said and done, we still have problems with respect to treatment of women, with respect to treatment of, scheduled caste people or caste related discrimination. We still have issues, but all said and done, we have come a long way and we are far less apologetic than our, people 1 or 2 generations before us were. So that's also a factor, I believe. So thank you. You've been very patient with me and I thank you for that.